Can anyone tell me, was the prosecution, anybody from the prosecution have to be there or no because they lost?
Yes.
Well, I see someone from the prosecution there.
It's Linda Drain Burdick and Frank George. You don't see Jeffrey Ashton. He's up in New York, we believe, right now, but they are there representing the state, and we'll hear what they have to say. They are the ones who most likely, Robin, want those 4 counts of providing false information to law enforcement. They want them consecutive. That means serve the maximum of 1 year on 4 different counts for a total of 4 years. But everybody else, this defense team wants them concurrent, all put together. As Cheney Mason was saying once, that it all happened at one time, and that's why they feel it should be concurrent, because all of her lies, if you will, were all done in one sitting with Detective Yuri Melich.
You can see the protesters who are lined up outside, some of them saying they wanted to speak out for little Kaylee, justice for Kaylee. Well, Ryan, let me ask you something. You know, Casey is a convicted felon. Could that factor into the judge's decision today?
It could potentially, and that's always a bit of a wild card here. She was convicted of check fraud in relation to stealing some money, I should say, writing some checks, some bad checks, from her friend Amy Huizinga, who was actually a witness in this trial. And so she essentially served that time with her time already served behind bars. But the judge could look at this and say, hey, this factors in, we need to change up the sentence a little bit. Now, the other situation with that, though, is that this is a misdemeanor. These counts of lying to police, they're all misdemeanors. So that changes the picture a little bit. So the judge could always say, yes, you're a convicted felon. I feel the need to give you consecutive sentences. But he could also say the charges are much lower, so maybe not. And there's Judge Perry walking in the courtroom right now.
All right, and so they're standing for the judge. As soon as he begins speaking, we'll go right to him, and it should be about right now.
You may be seated.
Okay, Madam Clerk, you may call the case.
Case number 2008 CF 15606, State of Florida versus Casey Marie Anthony.
Okay, let the record reflect that the defendant is present along with counsel for the defendant, Assistant State Attorney. Both sides ready to proceed?
Yes, sir.
I believe so, Your Honor.
Mr. Mason, before we proceed to sentencing, Mr. Baez, you had asked me to reserve ruling on your motion for mistrial.
Withdraw that, Your Honor.
Okay. Okay, that takes care of that. The defendant, Casey Anthony, is before the court for sentencing on counts 4, 5, and 6, providing false information to a law enforcement officer. Mr. Baez, do you know of any legal cause why we should not proceed to sentencing at this time, sir?
4, 5, 6, and 7.
And 7.
And the only legal cause that we have would be the previously filed nuisance tax, none of it. No legal cause like you can't proceed to sentencing with the subsequent remedies if she takes them.
Would the state care at this time to present any matters relative to aggravation?
Not on that issue, Your Honor, no.
State care to present any issues at this time concerning any other matter?
Your Honor.
Yesterday, I filed a motion to tax special costs of investigation and prosecution and to reserve jurisdiction. The only reason that I would bring this up prior to the actual sentencing has to do with the jurisdiction of the court, once sentence is imposed, if defense counsel intends to appeal the misdemeanor convictions, then this court would not be able to entertain a later hearing until that matter is resolved as it relates to costs of investigation. If, in fact, that is their intent, what we would ask is that the court bifurcate the sentencing hearing, proceeding to the matters of punishment. First, the issue of cost of investigation is not intended to be punitive. and I believe can be handled at a later point in time in a bifurcated type of proceeding that would not divest the court of immediate jurisdiction to handle this matter so that this can be closed as expeditiously as possible. That is the only thing I wanted to bring up at this time.